The problem isn't that AI is too risky for legal work. The problem is that no one has told you which parts are risky and which parts aren't. Those are completely different things. And conflating them is keeping you on the sideline of something your colleagues are already using. Not because you're risk-averse, because you're rigorous, because you've spent years building a practice on the principle that you do not certify what you cannot verify. And every piece of AI content you've encountered so far has either ignored that standard completely or told you to wait until the guidance catches up. This video is neither of those things. By the end of it, you'll have a specific map. Which AI applications in legal work carry real risk, which ones don't, and exactly where to start without touching either. So let's start by naming what you're actually worried about. Because the caution is not irrational, it's professionally appropriate, and it deserves to be taken seriously before anything else happens in this conversation. The first concern is the one everyone in legal practice knows by now: hallucination. AI tools, including the most capable ones, generate content that sounds authoritative and is factually wrong. For general content, that's a quality problem. For legal work, it's a liability problem. The case citations that don't exist, the statute language that's slightly off, the procedural rule from a different jurisdiction. These aren't edge cases. They're documented, they've appeared in real filings, and at least one attorney has already faced sanctions for submitting AI-generated citations without verification. That concern is real. It belongs in your assessment. The second concern is confidentiality. When you paste a client's situation into a public-facing AI tool, you're putting that information into a system you don't control, with data retention policies you haven't reviewed, under terms of service your client never agreed to. That's not paranoia. That's a straightforward professional responsibility question, and most bar associations have now issued guidance that essentially confirms the concern without fully resolving it. The third concern is subtler, and almost no one names it directly. It's the disclosure question. If AI assisted in producing work product, a brief, a memo, a demand letter, do you have an obligation to say so? The answer varies by jurisdiction, is still evolving, and is genuinely unclear in ways that make a careful attorney hesitant to move until there's more clarity. All three of these concerns are legitimate. None of them mean what most legal professionals have concluded they mean. And that conclusion, AI is too risky for legal work, full stop, is the myth this video is going to disaggregate. Now, here is the thing that general AI content almost never says to a legal audience. Risk in AI use is not uniform. It depends entirely on what you're using AI for, what you're putting into it, and what happens to the output afterward. Those three variables change everything. Think about it this way. There are applications where the risk profile is genuinely high. Drafting client-facing documents and sending them without attorney review. Inputting confidential client facts into a public AI tool to generate legal strategy. Citing AI-generated case law in a filing without independent verification. These are high risk. Not because AI is inherently dangerous, but because the downstream consequence of an error is a consequence you bear professionally. Then there's a completely different category. Internal research scaffolding, summarizing publicly available materials, statutes, regulations, published opinions, to orient yourself before going deeper. Drafting internal memos for your own review and revision. Organizing deposition notes from your own files. Building a first draft of client communications that you then rewrite. The risk profile of that second category is fundamentally different. Not zero. Nothing in legal practice is zero risk. But the exposure is manageable in exactly the same way you manage every other tool you use that requires judgment before the output goes out the door. Here's the principle underneath all of this. AI produces. You certify. That division of labor is not new. It's what you do with a junior associate's first draft. It's what you do with a paralegal's research memo. The tool changed. The professional responsibility didn't. What the three concerns from a moment ago are actually protecting is not the general category of AI use. They're protecting against a specific failure mode, output that goes to a client or a court without the professional judgment that transforms a draft into a certified work product. Keep that distinction in place, and the risk landscape looks completely different. So let's get specific. Because the map is only useful if it names real places. The first application that works well for legal professionals and carries essentially no confidentiality risk is research orientation. You have a matter in an area where you're not deeply specialized. You need to get oriented quickly before you go to Westlaw or Lexis. You open Claude, not with client facts, not with names or case specifics, and you type something like, "What are the main legal frameworks courts apply in trade secret misappropriation cases in federal court? What are the key elements and typical evidentiary disputes?" What comes back is not a citation you can rely on. What comes back is a conceptual map, the landscape of the issue before you spend billable hours navigating it. You then verify everything through proper research tools. The AI didn't do your research, it gave you a faster starting point. That's a different thing entirely. The second application, internal memo drafting. You need to summarize a legal issue for a partner or for your own files. You type the structure, not client facts, the legal framework, and ask Claude to draft a first-pass memo. You rewrite it, you review it, you correct what's wrong. You didn't outsource the judgment, you saved 45 minutes on the scaffolding. The third, deposition preparation. You have a deponent whose background involves publicly available information, a published expert, an executive with public filings, a professional with publicly searchable history. You ask Claude to organize that publicly available material into categories relevant to your deposition strategy. No confidential client information involved. No citations in a filing. Just organized public information. Faster than doing it by hand. And the fourth, the one that surprises most legal professionals who try it, client communication drafts. The first draft of a status update letter. The explanatory paragraph that describes a procedural development in plain language. The FAQ your client keeps asking. You prompt Claude with the structure and the key points, no names, no case specifics, and it gives you a draft. You then rewrite in your voice with your judgment before it goes anywhere. Here is the reframe that sits underneath all four of these. Your judgment is what transforms AI output into legal work product. AI can generate a structure. It cannot know that the third argument in that brief will read as overreach to this judge. AI can summarize a statute. It cannot know that the way this particular opposing counsel has argued that statute in prior matters changes your approach. AI can draft a letter. It cannot know what your client is actually afraid of and what they need to hear to feel confident in the process. That knowledge is yours. It took 15 years to build. It is not replicable by a tool. It is the ingredient the tool cannot supply, and the ingredient that makes everything the tool produces actually usable. That's not a vulnerability in your position. That's the job. If what you want next is not a framework but actual prompts, the specific language to type for the specific tasks just described, built for legal professionals who are not coming from a technical background, there's a resource in the description built exactly for that. It's the legal edition of a profession-specific playbook. It gives you what to type, for which tasks, with the guardrails already built in. No course, no certification. Just the prompts that work. Tested on real, legal work. Link in the description and in the pinned comment. Now, the one thing to do before the end of this week. Not a workflow, not a new tool to install, not a course to complete. One task. Under 10 minutes. No confidential client data involved. Here's exactly what it looks like. Think of a legal issue you've been asked about recently, or one you're working on now, where you needed to orient yourself quickly before going deeper. Open Claude. Type this or something close to it. I need to orient myself on area of law. Can you give me a plain language overview of the main legal frameworks, the key elements courts typically analyze, and the most common points of dispute? I'll verify everything through proper research. I just need a working map of the landscape. Read what comes back. Don't cite it, don't send it, don't use it as a final answer. Use it the way you'd use a conversation with a knowledgeable colleague who happened to be available at 10 p.m. when you needed a fast orientation. Then go verify. What you'll find, if you haven't tried this yet, is that the output is more useful than you expected. Not because AI knows more than you. Because orientation is something it does well, and orientation is something that has always eaten time you didn't have. The objection that comes up here for most legal professionals is time. I don't have the bandwidth to learn something new on top of an already full practice. And that's real. But what was just described doesn't require learning. It requires opening a browser tab and typing one paragraph. The question isn't whether you have time to learn AI. It's whether you have 8 minutes to find out if this specific thing is useful for the work you actually do. Everything else, The workflow, the integration, the systematic use comes after that answer, not before. That's the correct sequence. And the sequence starts with one task: before Friday. If you want the specific prompts, not the framework, the actual language, for the tasks described in this video, the legal edition of the Playbook is in the description. It's the next step for someone who's ready to move from the map to the work. What's the specific AI concern that's kept you from using it in your practice? And after watching this, does it still land the same way? So here is what you now have. You arrived with a concern that most AI content either dismisses or amplifies without resolving. And the concern was correct, just aimed at the wrong target. The risk in AI use for legal professionals is not categorical, it's specific. It lives in three places: unverified output that goes to a court or a client, confidential client data in public tools, and certified work product that bypasses professional judgment. Keep AI out of those three places, and the risk profile of everything else looks completely different. What the last 20 years of practice built is not competing with AI. It's the thing that makes AI output legally usable. The tool produces a draft, you certify it. That's not a new division of labor. That's the same division of labor you've always applied to every research memo, every junior associate's brief, every paralegal's first pass. The source changed. The professional responsibility didn't. The thing worth holding onto from this is not a step or a tool. It's a sentence. Your judgment is not what AI is replacing. It's what AI requires in order to produce anything worth using. That's the real inversion. And once it lands, once you actually feel it rather than just understand it, the question stops being, is AI safe for legal work? And it becomes, where does my judgment most usefully meet this tool? That question has a much better answer. And you already have everything you need to start finding it before Tuesday.